In this frequently asked questions video, we're going to talk about mediation. Mediation is done by a mediator who is a neutral party. And what that means is that they don't represent either party. Their job is to establish rules, keep the parties focused, and help the parties work towards any issues that need to be resolved. The mediator's success can depend upon the parties' preparation, their level of engagement, and willingness to negotiate and come to an agreement. During our current pandemic, COVID-19 times, most mediations are occurring online via Zoom, or at least being offered as an option to do it online. If you do it online, you will be in a separate Zoom room from the other party, at least initially, and the mediator will go in between the two different rooms to speak to both parties. If things are going well, the mediator may ask you if you would like to go into the room with the other party. If mediation is successful, and successful can mean that you successfully agree or mediate everything, or that you only come to an agreement on a few disputed issues, the mediator will draft a mediation agreement, which is also called a memorandum of understanding. If you are not successful, the mediator will draft a document that indicates that the parties were unsuccessful at resolving any issues. There's a few things that you can do to make the most of your time in your mediation session. The biggest thing is prepare. If you have an attorney, you should discuss what the issues are and what your position on those issues are with your attorney. Your attorney can advise you of what you are legally entitled to or what the legal standard is for those issues before you decide what you are agreeing to or not agreeing to. Knowing your position can help to make the time much more successful, because rather than waiting till the day of mediation to figure out what you want or what you would like to ask for, if you have prepared beforehand, the negotiations will most likely go a lot smoother. If you have children, or if you are mediating issues relating to your children from parenting time or child support, remember that your children's best interests come first. Not what's best for you, but what is best for your children as you are thinking about what you are agreeing to or not agreeing to, or what is being proposed to you. If you go in with the mentality, and some people do, that they're not going to budge on anything, then the reality is that your mediation just will not be successful. If you keep an open mind, if you have clear ideas of what you would like or what you are willing to negotiate on, you will probably have more success in that session. It's helpful to have an attorney present during the mediation if they're able to de-escalate a situation. Sometimes there is just so much hostility and emotion between parties that even if something is reasonable to agree to, because of that hostility, a party may not. So sometimes having a good attorney who can kind of de-escalate the situation and may lead to better outcomes or more agreements combined with a good mediator. If you don't have an attorney present, it is still probably smart or prudent to consult with one beforehand, before you go into the mediation, just so that you know what your rights are and you understand, what are things to agree to, what are things not to agree to, or what are the implications if you do agree to them down the road. An attorney can also review your mediation agreement or your memorandum of understanding, and again, just make sure that everything is accurate, it's correct, and it's enforceable. An attorney can give you legal advice specific to your case, but a mediator cannot. A mediator can give you general legal information. So if you are looking for legal advice, or if you're unsure about something, you do want to consult with an attorney before the mediation session. I hope this video was helpful to you, and we look forward to you joining us on our next frequently asked questions video. Thank you.